Ch16 in the federal court system. I'm your instructor, Mrs. Stewart. Welcome, and you'll be joining me for the next 5 minutes. Now, in the federal court system, the major players that you'll find are the federal judges. Presidents love the idea that they have the ability or maybe the opportunity to appoint federal judges to the Supreme Court as well as the federal court bench. In order for a president to have his nominee appointed to the federal court bench, he must get prior approval or Senate confirmation on his appointment. And presidents have failed 20% of the time to get Senate confirmation of their nominees to the Supreme Court, which is a percentage that is much higher than any other federal position. Now let's look. This is a wonderful view of the Supreme Court of the United States, but let's move on. The only thing we're going to talk about in this segment is the nature of the judicial system. The nature of the judicial system is based on the theory that justice will emerge out of the struggle between two contending points of view. Simply means there are 2 points or 2 sides to every story, and we all know that too well. In the federal judicial system, there is criminal law and civil law. Cases that are based on criminal law means that an individual is charged with violating a specific law. Criminal law provides punishment for crimes against society. However, civil law does not involve a charge of criminality. Yes, that's a real word. Instead, it concerns a dispute between 2 parties and defines the relationships between them. Now, the major players or participants in the federal judicial system are the judges. However, there are many other players that are incredibly important, and we wouldn't have the federal courts without these folks. The first one are litigants. You cannot be involved in a court case at the federal level or even at the state or local level unless you are a litigant. A litigant can be either a plaintiff or a defendant. A plaintiff is somebody who brings the complaint to the court or the charges, and the defendant is, well, exactly that. They're trying to defend their name against the charges from the plaintiff. Now, in order to be a litigant, you must have what's called standing to sue, which means that you must have a serious interest in the case, which is typically determined by whether or not you have sustained or are in immediate danger of sustaining a direct or substantial injury from another party. Standing to sue simply means you have an interest in the case, meaning you've been impacted in some way by the case. The courts have broadened the definition of what standing to sue actually means to include what's called class action lawsuits. Now let me give you an example. A class action lawsuit could be one where somebody has found that Verizon is overcharging its cell phone users in a criminal manner. And because you're a Verizon cell phone customer, you've been included in that class action lawsuit, but you won't actually have to attend court. Okay? Court cases must also be justiciable disputes, which means they have to be capable of being settled as a matter of law. If they cannot be, they will not make it to court. There are just a couple of more participants in the judicial system that make the judicial system what it is. One of those groups are attorneys. Attorneys are major, indispensable actors in the judicial system. There are over 1 million attorneys that are practicing law in the U.S. today. Now the problem is that access to lawyers is inherently unequal because they cost money. The wealthy can afford high-powered attorneys who can invest many hours in their cases, and the poor are often served by overworked attorneys with few resources to devote to their cases, which means that there is a much higher conviction rate when a defendant has a lower socioeconomic status. Now folks, the system's not perfect, so we'll have to work to solve that. Now, if you have an interest in the case or you've been impacted by in some way or shape and the end result of the case could impact you, you have a duty, you also have a right to present what's called amicus curiae briefs to the court, which are legal documents or briefs that could impact the case in several ways and the outcome of the case. And the last point to consider is there's going to be several court cases that we're going to be learning about in this chapter as well as in the last unit. This one should stand out to you above all else. This is Brown versus Board of Education. I'm going to leave you with the question, what do you know about this case and how has it impacted us today? Enjoy!